Mistake is a fundamental concept in law that refers to an error or incorrect assumption that leads to a legal consequence. Types of mistake. There are several types of mistake, including error of fact. An error of fact occurs when a person believes a fact to be true that is actually false. Error of law. An error of law occurs when a person believes a legal principle to be true that is actually false. Error of judgment. An error of judgment occurs when a person makes a decision based on incorrect assumptions or incomplete information. Error of understanding. An error of understanding occurs when a person fails to comprehend the meaning or implications of a contract or agreement. Examples of mistake: contractual. Mistake. A person who signs a contract without reading it carefully may be considered to have made a mistake. Mistaken payment. A person who pays a debt to the wrong person may be considered to have made a mistake. Mistaken identity. A person who mistakenly identifies another person as the owner of a property may be considered to have made a mistake. Defenses to mistake. There are several defenses to a claim of mistake, including ignorance of the law. A person who is ignorant of the law may not be able to claim mistake as a defense. Contributory negligence. A person who contributes to their own mistake may not be able to claim mistake as a defense. Waiver. A person who waives their right to claim mistake may not be able to do so. Application of mistake in various jurisdictions. Mistake is a widely recognized concept in various jurisdictions, including United States. The concept of mistake is recognized in the United States, where it is often used to determine the validity of a contract. United Kingdom. The concept of mistake is recognized in the United Kingdom, where it is often used to determine the validity of a contract. Australia. The concept of mistake is recognized in Australia, where it is often used to determine the validity of a contract. Mistake and contract law. Mistake is closely related to contract law, as it often involves a breach of contract. In contract law, a party who makes a mistake may be able to rescind the contract or claim damages. Mistake and tort law. Mistake is also closely related to tort law, as it often involves a tortious act such as negligence or misrepresentation. In tort law, a party who makes a mistake may be liable for damages. Mistake and equity. Mistake is also closely related to equity, as it often involves a situation where a person has been unfairly treated. In equity, a court may grant relief to a person who has been unfairly treated due to a mistake. Conclusion. Mistake is a complex and nuanced concept that is widely recognized in various jurisdictions. To establish a claim of mistake, the following elements must be proven: error, causation, and damage. There are several types of mistake, including error of fact, error of law, error of judgment, and error of understanding. Defenses to mistake include ignorance of the law, contributory negligence, and waiver. In conclusion, mistake is an important concept in the law that can have significant consequences.